Okay, hello and welcome back to part 4 of misrepresentation. Last time we were talking about rescission and restitution. We talking about last time we talked about the restitution, in the status quo ante. Now I want to talk to you about affirmation. Affirmation is a promise made to solve a problem. It is irrevocable and it only happens after the misrepresentee is aware, is aware of the misrepresentation. Affirmation requires that the misrepresentee has the informed choice to terminate the transaction. Parties have the option to rescind or affirm an agreement created on the basis of misrepresentation. If the transaction is affirmed, it will be irrevocable. Affirmation can arise when the misrepresentee becomes aware of the misrepresentation. For affirmation to be effective, the misrepresentee must be aware of the misrepresentation. Okay? For affirmation to be effective, the misrepresentee must be aware of the option to terminate the agreement. If the misrepresentee is aware of the misrepresentation and demands for performance of the contract, affirmation will be inferred by the court. In the case Kepchak versus Dyson, the court held that even though Kepchak remained in possession of and operated the hotel business after being aware of the misrepresentation, the conduct of Kepchak does not constitute affirmation. For discovering the misrepresentation, Kepchak communicated their concerns to Dyson. This conduct would be seen as an intention to repudiate. Alright, so next section I want to talk about under rescission and restoration is intervention of the third party right. Okay, title of property acquired by the misrepresenter is voidable. Until the title is voided, the misrepresenter held the legal title and can transfer the title to a bona fide purchaser for a value without notice of the underlying equity or difficulty with the title. Okay, so next section I want to look into is execution of the agreement. Alright, so next section of restoration and misrepresentation. No, restoration and rescission, right? Next section, section 4, is execution of the agreement. Once the agreement or contract has been executed or performed, there will be barriers or challenges to rescission in several situations. An example mechanics give us a real estate transaction induced by innocent misrepresentation will follow a rigid rule known as the doctrine of execution. This doctrine of execution states that when the real property conveyed in exchange of the purchase price, the transaction cannot rescind the misrepresentation. So, in Rescission versus Nesbitt, this case was about a leasehold property where the assignment of the lease and the check was exchanged for the price of money. A few days after, the purchaser discovered there were other mistakes on the material. The purchaser took the opportunity to stop the payment on the check and sought rescission. The court ruled that the party had the intention to cause the transaction and the contract was properly executed. Because of the strict rule used in the doctrine of execution, especially in real estate, it is a custom practice for the purchaser to investigate title and examine the property subject prior to the closing transaction. Okay. The execution bar has been frequently applied to the sales of security and sales of goods so as to preclude the rescission. Thus, executed contract do not have the right of rescission. When the payment was made for the transaction with the intention to close the transaction, execution would have taken place. So, life insurance gives the insured a 10-day right of rescission. After that time, the policy will be enforced. In the case Leaf versus International Galleries, Lord Denning states that innocent representation can be grounds for rescission even after the contract has been executed. Reason being is that the right for rescind for misrepresentation could not survive beyond a point in time when the right to terminate the contract for the breach of contract would expire. Page 345. Basically, after the contract has been executed, the right of rescission is still available. However, it cannot be rescinded it is beyond if it is beyond a point of time. Okay? Even if innocent misrepresentation were discovered not long ago, there was ample of time to discover the misrepresentation. Alright, so next section of rescission and restoration is lashes. Section 5, lashes. If a claim for rescission is brought in and delayed at an unreasonable time, this will be considered an equitable defense. It is a legal doctrine that states that if you take too long to assert your legal right, you lose the entitlement to a right or compensation. You cannot just sit on your equitable right. In the case Lindsay Petroleum Oil Company versus Heard, it was ruled that the delay would not constitute the defense. The doctrine of lashes will not allow the plaintiff to recover anything or do anything because he or she was late in seeking relief. There is a limit for the claim, for the legal claim, okay? Alright, so next section I want to look into is sections of restitution and rescission is merger in a subsequent warranty. In commercial agreements, there are usually a clause called representation and warranties. This section will reiterate what has been agreed upon over the course of negotiation. This representation will become a part of the agreement. If what is represented in the agreement is not true, the falsity will be considered a breach of contract. The misrepresentee will be able to seek remedies for the breach of contract. Pennsylvania Shipping Company Co. versus Compagnie Nationale de Navigation is a case about a purchaser buying a tanker from a vendor who made some guarantees in the agreement. Okay, so the representation was not true. In this case, the court ruled that rescission for pre-contractual misrepresentation was not available because the pre-contractual representation had merged with the warranties and guarantees in the agreement. Thus, the only way to terminate the contract was the remedies provided in the contract. In Leaf versus International Galleries, once the representation become part of the contract, any breach of the contract will have remedy available at common law. Lord Denning states that innocent misrepresentation can give rise to rescission even though the purchase price has been paid and the chattel in question delivered. The court refused to grant rescission because it was not reasonable to grant rescission after the lapse of 5 years. Alright, so that's the end for this part. Now I'm going to actually come back and talk about rescission and restitution, more about that later on. Okay, so until next time, you guys take care and please come back. Thank you.